My name is Benjamin Henrion. I work for the FFI. We have an association with 3,000 companies and many independent software developers. We are concerned that the current ACTA negotiations cover patents. One thing we are concerned is the level of injunction that a judge has to apply to suspicion of infringement. There was a hearing in the European Parliament in the Legal Affairs Committee about the review of the IPRED 1 directive. And one French expert said that the directive had the effect to change the level of injunction from quasi-certainty of infringement, to give an injunction, to suspicion of infringement. And in patent problems, it creates a disimbalance that can offer very powerful weapons to enforcers. Let's say in the United States, they have, according to latest statistics for the year 2008, up to 30% of what is called patent trolls. And on the US side, they have also a famous case which went to the Supreme Court, named the eBay versus Merck Exchange. Merck Exchange was a so-called patent troll that had a patent on the buy now feature, and they sued eBay for that, asking for shutdown of the eBay service. And the case went to the Supreme Court, where the court says that they were denying the automatic injunction. So now we have a conflict between the status of the law in the US and the one in Europe, because the IPRED 1 directive changed the threshold of injunction from quasi-certainty to suspicion. Now what the French expert said in the hearing was that all judges were reluctant to issue injunction in case of suspicion, because that might be too powerful. So do you intend to export IPRED 1 and this level of injunction to the United States and other countries?
Well, first of all, on patents, let's remember that we will not touch anything that is substantive as to patent right. This has to be clearly understood. Now, as you know, the substantive law in Europe on patent on top of it is not harmonized. But some enforcement measures through the IPR enforcement directive, what you call IPRED 1, which is the only one in force, have common rules, and we will base ourselves on these rules. If the United States have different rules, there will be a discussion, obviously, in a negotiation and arbitrage or changes. But we will clearly, we are defending our acquis. This is our negotiating guidelines, is to defend the acquis. So will I export it? I think it's too far-reaching because it doesn't work like that. But will the existing IPR enforcement directive be the basis of the Commission negotiation? Yes, but not more. So, for instance, there are no criminal sanctions on patents. We're not going to defend that. Thank you. Sir, please. Blue sweatshirt.
My name is Martin Köhler from the Green Group in the European Parliament. Just to switch the question that was posed to you twice, do you think that the Parliament asked you to limit ACTA negotiations to counterfeiting? I would like to pose the question in this way. Second question, and you might not want to respond on them, in the FTA negotiations, the free trade agreements that are being negotiated by the Commission now with Korea, Canada and also the Central American countries, there is a formulation in terms of ISP liability which goes beyond the e-commerce directive and leaves open, so it's a transformation of the e-commerce directive in a very peculiar form. Would you think that in these FTAs the acquis is being blurred?
Well, to the first question, I mean, if you're a member of the Parliament, I will not comment what the Parliament said. I can only read it, and if you take the whole resolution, it mentions counterfeiting in paragraph 8, and it mentions copyright enforcement, particularly in the digital environment, in paragraph 9. And I know that perhaps you would like us only speak of 8, but one has to read the whole document. In any case, the line is very clear. The line for us is the EU legislation. And I suppose the Parliament as well, but that's not for me to say. So we will respect the existing EU legislation, which allow me to answer your second question. You say that we're, if I understood you well, in our free trade agreements are changing the e-commerce directive. I really don't agree with that. And when we negotiate free trade agreements, we do also with the colleagues who are the very authors or the very guardians, if you want, of these directives, and they wouldn't like us to change it. So perhaps there's a difference of interpretation there, but this is not our line. Thank you. Any other questions? Lady here, lady there, and gentleman there.
I'm Sylvie Forbin from Vivendi. I would like to, of course, to reassess our support to the exercise, which is the exercise of ACTA. And of course, we follow very carefully all the progress, and we hope that we will have an end as soon as you can in the near future. I am a little concerned by some interventions here and there regarding legal framework and your answer on acquis communautaire. Of course, we are proud of this acquis communautaire, and we think it's a good thing to export it. Nevertheless, an acquis communautaire is not something gravé dans le marbre. It is something in movement. And when we speak of legal framework, we know in the main markets of the world where digital economy is developing, that partly based on case laws, partly based on best practices, partly based on all the negotiation that we have on private and public ground, there are progress. So how do you assess some part of flexibility, or how this treaty will be adjusted in the future from the signature of the treaty, and in the future to adopt or to adjust to the technology progress and case laws achievements and legal framework changing in the countries, in the various countries. Thank you.
Thank you. You are right, of course, legislation by definition moves. International treaties can as well. If we were to wait that legislation on one topic doesn't move to have an international treaty, we would have no international treaties. So I note with pleasure that you are optimistic about the future of the treaty, because you already mentioned about updating the treaty, which is not there yet. I mean, we'll have to discuss mechanism on how to do this. We haven't reached that stage yet. But clearly, of course, we don't want, as you say, that things stay in the bubble for also reasons that technology evolves and you can have new problems appearing and old problems disappearing as well. So it's very pertinent, very relevant question, but we'll have to address it in due time. But we certainly keep that in our mind. Thank you.